infrastructure, mining, and other regulatory sectors. Our expert speaker, Ms. Sunita Patel, AGM in Legal EHS Compliance is Aparajitha. She has 12 years plus of experience in legal and compliances expertise across industries. She now leads Aparajitha's environment, health and safety domain, delivering strategic solutions to ensure regulatory alignment and risk mitigations. Today, we'll have a session with her to take across over this topic. Also, in case if there are any questions and answers, kindly take it after the session so that we'll be able to address all the queries. I now ask Ms. Sunita Patel to start with the session.
Thank you, Shreya. Let me share my screen. Is my screen visible?
Yes.
Yes.
This is an exclusive session on environment clearance. So here we are going to understand what is the framework for environment clearance, what are the different important definitions, what are the project and activities which is listed under EIA 2006, which requires a prior environment clearance. Is there any categorization of project and how the project has been categorized, on what basis it has been categorized, when the environment clearance is required, what are the activities that trigger the requirement of prior environment clearance, what is the validity, and whether the environment clearance can be retrospectively obtained, and what are the recent Supreme Court rulings or judgment with respect to that, and we are going to understand what are the compliances post obtaining the EC, and consequences and penalties, if any, and lastly is what are the services that Aparajitha is basically offering vis-a-vis EC and other regulations, rules, other regulations under EHS, falling under EHS. So first one, let us understand the framework of environment clearance in India. So basically, when we talk about the applicability, so EC, prior clearance, is applicable only to projects and activities which will have significant impact, environment impact. Now the governing law. So now the EIA, the Environment Impact Assessment Notification 2006, is is framed and it's notified under Section 3 of Environment Protection Act and Section Rule of Environment Protection, Section 5 of Environment Protection Rule 1986. So this is the legislation which primarily governs and regulate the process, entire process of environment clearance in India. Now, what is the statutory nature? So, to which area it is applicable? So, as we all know, that Environment Protection Act is a central legislation. So, consequently, the notification, the EIA notification 2006, framed under the said act, is applicable to the to entire whole of India, including J&K. Now, what's a primary notification? So, as said, so EIA notification is a primary notification that governs all the environmental clearances process in India. So, which project? It's the notification says as to which project is required to obtain prior clearances. There's a list being given in the schedule of this notification as to the projects which are the major projects affecting the environment, and the projects which where the prior clearances need to be obtained. And this notification has been amended by the central authority, that is the Ministry of Environment, for Environment and Forest and Climate Change over the time, like from the time it has been notified. So now the next is the nodal ministry. So the entire EIA is regulated under the central ministry, which is the Ministry of Environment, Forest and Climate Change. Now there are other relevant laws as well where clearances has to be obtained in case if the project is having any adverse impact or if it is located within that particular zone. So let's say the Forest Conservation Act. So any project, it applies to all those project and activities where there is a diversion of forest land use. So where any project or activity is set up in that area which comes under the forest zone, and where the forest land is being used or converted to non-forest usage, in that case uh, the clearance has to be obtained under Forest Conservation Act 1980, and the authority to issue the clearance under this act is Ministry of Environment, Forest and Climate Change. Now, in case of Wildlife Protection Act, this is applicable to project or activities which is situated in and around the protected areas, which protected areas like wildlife reserves, then tiger reserves, community area, community reserves or conservation reserves. So these are the areas where if any project or activity is being situated in and around this zone, then clearance has to be obtained under Wildlife Protection Act 1972. So the authority issuing the clearance is National Board of Wildlife or State Board of Wildlife as applicable. Now, in case of coastal regulation zone, so here any project or activity which is set up within the coastal zone, which forms a part of coastal zone under this regulation, under this notification. So in that case, prior environment clearance has to be obtained. Now, who is the authority issuing the clearance under this notification? So again, it is the Ministry of Environment, Forest and Climate Change issuing the clearances under coastal clearance. Now there are other two act which is a separate legislation altogether. Now in this case, in case if any project or activity being situated anywhere, any location, but it's going to emit certain harmful air emissions, then in that case, which is going to impact the environment, in that case the project or that particular activity or the unit has to obtain consent to establish and consent to operate under the Air Prevention and Control of Pollution Act 1981. So likewise, this act, in case of Water Prevention and Control of Pollution Act 1974, if any project or activity or unit is going to emit is going to release any trade affluents or water affluents which is going to harm the environment, so in that case the unit has to obtain consent to establish and consent to operate under this act. Now, there are two important definitions that one should be knowing to understand the concept of environment clearance wholly. So, first is the crucial definition, which is environment. Now, here, so environment is very clearly and statutorily, it's defined under Section 2A of the Environment Protection Act in 1986. So where it includes, so it's a very broad definition and it's an inclusive definition. So if we see the definition given under the EP Act 1986, it says that it includes water, air, land, and the interrelationship that exists between this natural resources with human being, other living creatures, plant, microorganisms, and property. So basically, the literal meaning over here is the environment. The definition of environment is including all the living beings, natural resources, as well as the man-made resources. So the literal definition, if we see, then it is the enviro or the surrounding in which the living being, the natural resources, and the man-made resources basically is accommodated and interact with each other. So that's a literal definition of this meaning of this definition environment. Now, the next is project proponent. Now, project proponent, though it is widely and extensively used by the central authority, that is the Ministry of Environment, Forest and Climate Change, throughout the notification and guidelines, but it doesn't define the word project proponent. It doesn't statutorily define the word. So the definition that I have curved over here or specified over here is out of the FAQ from wildlife clearance, which is there on the Parivesh portal, which is like an online portal for obtaining the environmental clearance or other green clearances. So what the definition says is project proponent means an individual. Again, it is a bit of inclusive. So it means individual, public or private entity or government entity. So basically it is including the individual entity, which may be public or private, or government entity, which is having ultimate control over the affairs of the project. So any activity or project where the ultimate control is either by the individual or by any entity, which may be public or private, or any government entity, then such entity or individual will be considered as a project proponent. Now, and this individual or the project proponent may be authorized by authorized individual within that entity. So it may be either the board of directors or any other competent authority within in that entity, or it could be firm or LLP or joint venture. Now, the notification, if we see the notification, EIA notification 2006, it doesn't define, but it outlines the roles and responsibilities of a project proponent. So in that, if we see, the project proponent has a vast responsibility. So project proponent is a person who is responsible, a person or entity who is responsible for entire project, start from the obtaining of EC till getting the EC, environment clearance, from the authority, and the post clearance uh, compliances of terms and conditions specified in EC. So EC here, basically I'm referring to environment clearance. So what are the major project or activities requiring prior environment clearance? So if we see the environment impact assessment notification 2006, the schedule of this notification clearly gives the list of 39 category where prior EC is mandatory. So here I have categorized few of the very important category from the list, from the schedule, where the prior EC is required. So industries, I have covered the chemical industry, thermal power plant, distillery, paper and pulp, sugar industries, chemical industries, nuclear. So likewise, now in commercial estate, it is the industrial estate, parks, complexes, all special economic zone, biotech parks, or any leather compliances. Construction is the cement, building construction, township, development projects, infrastructure with respect to highways, ports and harbors, airports, in case of any ship breaking yards. Now, in case of affluent treatment plants, common municipal solid waste management facility, then common affluent treatment plants, then common hazardous waste treatment and disposal facility. Now here one thing to note over here is biomedical waste treatment facility. It was not there in the original schedule, so it was added in the year 2015 wide notification uh, by the Ministry of Environment, Climate and Forest and Climate Change. Now, one more thing, in year 2024, pellet plant has been included, has been categorized, and a prior EC is mandatory for any project or activity which is going to undertake the uh, activity of pellet plants. So this is one of the recent change actually in the list. Now other projects. So what are the other projects? So now what we have seen is the list of activities or projects which is there or listed in the EIA notification 2006 has to obtain prior clearance. So is that the only list, or there's another list, other list as well, where prior ACE is required? So there's other list where there are other projects and activities which require where a prior AC is required. Now, any project or activity which has been undertaken in the following zones require prior EC irrespective of the category, whether it is falling under category A or category B. Now again, the B is classified into B1 and B2. Whatever, irrespective of the category, prior AC is mandatory if any project or activity is being located or going to be located in the following zones. First one is the protected area. So protected area is basically the national park, wildlife sanctuary, community zone, or any community zone, or like a tiger reserve, or like a, yeah, so this areas. So in this case, a prior EC is mandatory. Now, if any activity or projects which is located within the range of 10 kilometers of this protected areas, in that case, prior AC has to be obtained. Now, uh, if the activity or project is located within that 10 kilometers range, then any project, whether it is falling under category A, whether it is falling under category B, B1 or B2, it will be considered as category A. And the appraisal of the project or activity has to be done by the central authority, which is the Central Expert Appraisal Committee. And in addition to that, so the clearance has to be obtained from wildlife board. And in case of, if it is central, then central wildlife board, and in case if it is falling under the state zone, then the state wildlife board. Now the next one is eco-sensitive area. So eco-sensitive area basically is notified under the EP Act, by the Ministry of Environment, Forest and Climate Change. Now, eco-sensitive area is the area or zone which is around the protective area. So, any activity that is being carried out or any project that is being going to be located in this eco-sensitive area, and if it is notified by the central authority, so in that case, prior EC has to be obtained. Now, critically polluted area. Now, critically polluted area and the notified industrial area. So, the authority the notifying any area as critically polluted area or notified industrial area is the Pollution Control Board. At a central level, it is Central Pollution Control Board, and at state level, it is a State Pollution Control Board. Now, this how it is categorized. So the categorization basically is done on the basis of comprehensive pollution index score. So if the pollution index score is going to be somewhere between 60 to 70, in that case it will be considered as a severely polluted area. And if the pollution index score, the comprehensive pollution index score, if it's going to exceed beyond 70, in that case, the area will be, or the zone will be categorized as critically polluted area or the notified industrial area. So anything, any terms with respect to this is regulated by the State Pollution Control Board or the Central Pollution Control Board. So any project or activity which is located in this zone certainly has to obtain prior clearance, and if it is falling in any of the category, let's say if it is falling under red category or red, orange category, blue category, except to white, or green category except to white, in that case they have to obtain consent to establish and consent to operate as well. Now Western Ghats. Now Western Ghats, initially if we see, it's the certain areas of Ghats in notified by Ministry of Environment, Forest and Climate Change in Maharashtra. So in one of the case where NGT has directed the ministry to frame ecologically sensitive area, notification with respect to ecologically sensitive area. So now it is still at a draft stage. So what the draft is, notification says that any entity which is falling under the red category or which is highly impacting the environment, let's say if it is under thermal sector, or which is into thermal sector, yes, which is into thermal sector, or which is into red category of industry, falling under red category. So in those cases, those industries will be strictly prohibited from operating in those areas which is notified in the draft ecologically sensitive area. Now the draft is it's like the Ministry of Environment, Forest and Climate Change has agreed to finalize this by end of this month, that is August 2025, and submit the progressive report to the National Green Tribunal. So it's still at a draft stage. And in Western Ghats, basically in the draft notification, they have covered around 56,825 square kilometer area, spreading across six states, which is like Gujarat, Maharashtra, Goa, Karnataka, Kerala, and Tamil Nadu. Now under coastal regulation zone, so any project which is falling under the coastal regulation zone has and which is notified under the coastal zone regulation notification uh, 2019. So in that, if any project is falling within that zone, then certainly prior clearance has to be obtained. So one of the very recent example that I can quote over here is the coastal, a very huge coastal project being developed in Mumbai. So again, in that case, if any project is falling within that zone, or it is create or developed in that coastal zone area, then certainly prior AC is required. Simultaneously, and same likewise in case of forest zone. Now the forest in the zone which comes under the forest area is notified under the Forest Conservation Act. So any project or activity falling within that area, so forest clearance has to be obtained. Now here, coastal zone and forest clearance can be obtained from the Ministry of Environment, Forest and Climate Change, whereas in case of other like protected areas, so the relevant authority or board under the Wildlife Protection Act has to be approached. So when the EC is required, so as we know that the list which is given in the schedule of EIA notification 2006, which requires any project or activity requires prior EC. But when? So basically, prior EC is required before start of any construction work or preparation of any land. Now, what constitutes start of any project? So basically, if any construction work is going to happen, or any land filling is going to happen, or any equipment is going to be installed at particular site, or any deforestation or any cutting of land would be taking place at that particular area, will constitute the start of the project, or it's the first step for uh, yeah, so for initiate starting of the project. So in that case, prior EC has to be obtained. Now, what is excluded from the term start of any project? So basically, the securing of land. So securing of land doesn't require any prior EC. This can be done without obtaining any EC. But once the securing of land is closed and any activity is taken at the particular location, as said, like the construction work or clearance of the land, or any installation of any equipment for starting the project, in that case, before start of that activity, prior AC is required. So all the, now who has to, which project has to obtain prior AC? Now all the new projects or activities which is listed in the schedule of EIA notification has to obtain prior AC before starting any activity at that particular uh, at the location. Now, in case of expansion, the second and third talks about the expansion, modernization of existing project or activities, or any change in product mix in existing manufacturing activity. Now, if there's an existing the project is already existing and prior EC has already been obtained, but due to some change in business activity or any management concern, if the project uh, is going to expand or modernize its existing activity which is being carried out, so in that case, if the pollution load, if the change, if there would be change in total uh, total capacity of the project, if there will be a change in total capacity of the project, so in that case, only in that case, prior EC has to be obtained. However, in case where the expansion or modernization of the existing project will result in no increase of pollution load, so in that case the pollution load will remain the same, which is, or the threshold will remain the same, which is specified in the environment, existing environment clearance given by the Ministry of Environment and Forest and Climate Change. So in that case, prior EC need not be obtained again. So same applies for change in product mix in the existing manufacturing unit. Same, if the total capacity is going to remain the same and it's not going to impact the environment, and it will be within the threshold of the threshold being specified in the existing AC. So in that case, no prior clearance is required for the change or the expansion or modernization that is going to happen in the existing project. Now, here, so basically we are going to see the categorization of project. Now, project categorization. Under EIA notification 2006, project has been categorized into two, at a broader level, into two categories. One is category A and the second one is category B. So in case of category A, this is of a prime importance, a property which are going to significantly emit the impact the environment. So in that case, in case of category A, so the project or activity or the clearance has to be obtained by Ministry of Environment, Forest, Climate Change at central level. So the appraisal will be done by the environment impact here the appraisal basically would be done by the expert appraisal committee at central level. And in the case where the project is falling under category A, in that case, public consultation and environment impact assessment is mandatory. mandatory, and the project proponent has to submit environment management plan as well. So which basically talks about the mitigation plan. So how the project is going to mitigate the environment impact that would be created out of those large scale projects. Now, the second category is category B. Now, category B is further categorized into B1 and B2. Now, B1 basically accommodates those projects where the significant environment impact would be at a medium level. It won't be as large as category A. Now, B2 is the project coming under B2 category is where the significant environment impact would be very less or minimum. So now in the case of B1, so EIA and public consultation is compulsory. Now in case of category B2, public consultation is exempted. Now in case of there are certain other projects as well where the public consultation is not required. So which entire project which is falling under B2 category, so public consultation is not required. Now let us see how the categorization has been done. So basically the categorization, there are different criterias which on the basis of which the industry or the project or activity has been categorized. So one is the size of the project. Second is the location of the project. Third is the environment impact. And lastly, it is the capacity of the project. So here, if we see the cement industry. So in case of cement industry, now if the production capacity, let's say it's more than 1 million ton per annum, then in that case it will be categorized as category A. Now in case if the capacity is less than 1 million ton per annum, in that case it will be categorized as B1. Now in case of soda ash category, there are certain industries or certain activities or projects which is only categorized in category A. They don't have any further categorization in category B, like soda ash industry. Then in case of airports, in case of all shipbuilding yards, or any project or activity which is of defense or defense which comes under the defense category, or which is for national security, it is of prime importance, like any any highway construction which is close to the border area. So certainly keeping in mind the strategic importance or the national security, this project will completely fall under category A, and there won't be any sub bifurcation into category B. Now there are certain projects like highway projects. Highway projects, any new highway projects will come under the category. National highway projects will come under the category of A. If it is the state highway, then it will come under category B. Or any expansion that is happening to the existing highway, which is like exceeding 30 kilometers. So in that case, such project or activity would be considered as under category A. If it is less than 30 kilometers, then it will be considered as category B. Now under nuclear, if we see the nuclear power projects, in that case it will be completely covered under category A. In case of sugar industry, it depends on the molasses, whether it is molasses based or it is just a sugar cane. It's just extracting a sugar cane sugar juice from sugar cane. Now if it is a molasses based, then certainly it will be covered under category A. If it is only just extracting the juice from the from sugar cane, then it would be categorized under category B. Now in case of pulp and paper industry, now any industry which is into the manufacturing of pulp, it will be categorized under category A. And if it is only paper manufacturing without involvement or manufacturing of any pulp, in that case it will be categorized under category B. In case of integrated paint industry, so paint industry basically is covered under category B. Now, when we talk about building construction projects, township and area development, so in this case, there's a revision been happened recently in case of building and construction project and the activities which fall under township and area development. So here, any project where the area is between 20,000, where the built up area is between 20,000 square meter up till 1,50,000 square meter. So in that case, this project will be categorized as B2. B2, and any project which is exceeding the super build up area of more than 1,50,000 square meter. So those projects will be categorized under B1. And in now one recent development is for those projects which is falling under category B1. For those projects, they have to give the detailed environment impact assessment report along with the application for prior EC. Now, in case of township and area development projects, where the development or project would be exceeding 50 hectare area, or it would be exceeding 1,50,000 square meter area. So in that case, again, it would be categorized under B1, category B1. In this case as well, the project proponent at the time of submitting the application for prior AC, they have to give the detailed EIA report along with the environment management plan. Now, in case of the affluent treatment facilities, here the common municipal solid waste and common affluent treatment, then biomedical waste treatment will exclusively fall under category B. Category B. And with respect to common hazard waste treatment, it is again bifurcated into B1 and B2, depending on the capacity being handled by the waste treatment facility. So now the next is application for environment clearance. So there's a single window clearance portal being launched by Ministry of Environment, Forest and Climate Change in the year 2018, which basically provides a one-way solution to get all the green clearances or ECs. Now, there are four clearances that can be obtained through this portal, which is the forest clearance, wildlife clearance, environment clearance, and the last is the coastal clearance. These are the four clearances that can be obtained through one portal, which is basically in a short known as Parivesh portal. Now, the application for making for applying for prior environment clearance has to be made in form 1, and there's a supplementary form 1A. So any additional documents has to be submitted to the authority, probably after making certain amendments or after receiving certain suggestions or recommendations from the expert appraisal committee. So in that case, if any amendment has been made to the existing documents which were submitted earlier, so in that case, it can be submitted through form 1A. Now the fee. So basically the portal provides for online payment as well as for manual payment. So payment of fee can be made either way. Manual payment, in case of manual payment, challan will be generated and the payment has to be made via bank. Now, one important thing to note over here is the now there's a directive from the Ministry of Environment that if the prior EC has to be obtained, it is applicable to any project or any activity, and it has to be obtained under EIA notification 2006. And if it is not obtained and the project proponent files any application for consent to operate, it will be straight away rejected with reason, because if the EC is applicable, then prior EC has to be obtained before making any consent to operate. Now, in case so basically CTO won't be granted, or the renewal, in case of renewal, let's say if at the time of obtaining the CTO, prior EC was not applicable, but due to change in the legislation, later on it became applicable to the project, and simultaneously application has to project proponent has to make an application for renewal of CTO. So in that case, the CTO won't be granted unless and until the prior environment clearance has been obtained by the project proponent for that particular project or activity. Now, so as we saw that the clearance is the green clearance that has to be obtained falls under different legislations. So they doesn't come under the same legislations. So for that reason, EC and consent can be applied simultaneously. And in case of consent to operate, if the renewal is pending, then then the application or the challan or the proof of application for EC can be submitted to the pollution control board at the time of filing the application of CTO renewal, or at the time of grant of CTO, at the time of making an application for the grant of CTO. Environment clearance process. So basically, EIA notification 2006 has categorized the process into 4 stages. So first stage is screening, second stage is scoping, third stage is public consultation, fourth stage is appraisal. Now in this case, the screening, scoping and appraisal, these 3 activities is undertaken by expert appraisal committee at a central level and state expert appraisal committee, or the union territory expert appraisal administration at UT level. Now, if we see stage 1, screening, this screening is applicable only in case of projects falling under category, projects or activity which is falling under category B. Now, why this screening has to be done? So basically, the screening at the stage of screening, the expert appraisal committee will review the projects are falling under B category and will sub-categorize the project into B1 and B2 on the basis of whether the project has to submit detailed environment impact assessment report and environment management plan or not. In case if the project needs to submit the environment impact assessment report and EMP, that is environment management plan, in that case the project or activity will be categorized as B1, and where the expert committee comes to a conclusion that such project or activities where the public consultation is not required or the EIA report need not be submitted, in that case the project will be categorized as B2. So basically the main idea of this stage is categorizing the project into B1 and B2 on the basis of whether the project or activity or the project proponent for that particular project needs to submit the EIA report or EMP report. The second stage is scoping. Now, scoping basically is applicable only in case of projects or activities falling under category A and category B1. For B2, for all the projects which is falling under category B2, scoping is not required. Now, there are other category as well where the scoping is not required. So, for example, the building construction and township projects. So, in that case, scoping is not required because they need not submit the terms of reference document. So, in case of those projects, they have to submit conceptual plan. So instead of TOR. So for that reason, they have to submit conceptual plan. That is the plan of entire project uh, giving the detailed environment impact, the layout of the project, and so for that reason, scoping is not applicable in case of the project which is falling under item 8 of schedule of EIA notification 2006. Now for category A and category B1, so scoping, basically why this scoping is required. This basically the scoping is required to ascertain as to what are the criteria to be considered for finalizing the terms of reference. Terms of reference is basically list down all the criteria which which should be considered at the time of for preparation of environment impact assessment report, and which will consequently lead to finalization of environment management plan, which is again, in other words, we can say the mitigation plan. Now yeah, so basically the criteria, so the authority, that is the expert appraisal committee at central level, and the central state appraisal committee at state level, or UT administration at UT level, will analyze the different criteria, uh, which will list down the criteria which has to be considered at the time of while finalizing the environment impact assessment report. Now, the third stage is public consultation. So, public consultation again is applicable only in case of projects which is falling under the category A and category B1, and there are certain other couple of lists which is given in the EIA notification 2006, where the public consultation need not be carried out. So, for example, now in case of irrigation project, so any project or activity falling within uh, falling under the irrigation category, so they need not they need not conduct any public consultation. Now, any project which is of national importance or national security, so in that case as well, public consultation need not be conducted. Now, any project which is exclusively falling under category B2, so in those category as well, those for those project or activities, public consultation need not be conducted. And any project which is prime importance, national security, so in those category, the public consultation did not be conducted. So however, on the other hand, in case of project or activities falling under category A and category B1, so public consultation is mandatory. Now, who is the authority conducting the public consultation? So the here in this case, the project proponent has to approach the respective pollution control board within the zone or area where the project or activities to be going to be will be located. So in that case, they have to approach the concerned pollution control board authority for conducting the public consultation process. Now, what is like comes under the public consultation? So basically, public consultation is noting down the material concern of the local people being affected, who will be affected by the activity or the project, or the stakeholders who have basically who has a plausible stake in the project, in the environment impact that may happen due to the project or activity. So, the entire consultation material concerns of this stakeholders is being noted, and there's a separate report being prepared, which is known as public consultation report, and it has to be submitted to the authority along with the application form, either in form 1 or through the supplementary form, that is 1A. Now, the last stage is appraisal stage. Now, in case of appraisal stage, the expert appraisal committee at central level, and the state or UT appraisal committee or administration, as the case may be. So basically appraises all the documents, including the form, the pre-feasibility report, the environment impact assessment report, the environment management plan, and other documents, other clearances that has been obtained by the project proponent. So it will appraise all the documents, it will thoroughly check and review all the documents, and on the basis of its appraisal, it will recommend to the state environment impact assessment authority or the impact assessment authority at central level, whether the environment prior EC has to be granted or it has to be rejected to that particular for the particular project or activity. One more thing to note over here is, in case of scoping, in like at the time of scoping or at the time of preparing the conditions for TOR, that is terms of reference, if the appraisal committee, if the central environment appraisal committee or expert appraisal committee, if it finds out that at that stage, if it comes to a conclusion that EC did not be granted for this project, so at that time also it may recommend to the concerned authority for rejection of prior EC. So the next is validity of EC. Now, in case of validity of EC, so any application for extending the validity of existing prior EC has to be made in Form 6 via online through Parivesh portal. Now, what is the, so here we will see what is the what was the original validity notified by the EIA, and what, how it was amended later, and now as on date what is the maximum validity for certain kind of project. Now, in case of environment clearance, so here I have categorized uh, 5 categories. Now, one is the mining project. So mining project, the earlier, the original validity was 30 years or the lease term, whichever is earlier. Now, later on, the amendment took place, and uh, the project, so amendment happened, and in that case, it was project life for 30 years. Now, and the extension that can happen to mining project is 20 years extra additional extension is being granted. So the maximum validity for mining project can be 50 years, either 50 years or lease or end of mined life, whichever is earlier. So this is the latest ongoing validity for mining project. Now, in case of river valley projects, so earlier the original validity was 10 years. Later on, it was amended to 13 years and 13 years. So now the maximum validity that can be granted with including the extension is 15 years. It's including the extension. Now, in case of nuclear power projects, nuclear power project and other projects like the area development, construction, and industrial and other. So earlier, the original validity was 5 years. Now, for nuclear project, it has, the amendment had happened for 15 years. Now, the maximum validity, including the extension, it can be up to 20 years. That is, 5 years extension can be taken beyond 15 years. Now, in case of area development and construction, so earlier it was 5 years. Later on, it was extended to 17 years. And again, further with amendment, it was extended to 10 years. And only one extension can be granted for 1 year. So the maximum, making the maximum validity period for prior EC of this for a project under area development and construction, it would be 11 years and not exceeding that. Similarly, in case of industrial and other project activity as well. Now, CRZ clearance. So, in for the project or activity falling under coastal regulation zone in so clearance with respect to this project or activity. So earlier it was 5 years, 7 years. Now in the year 2023 in July through amendment. So the validity was extended from 5 to 7, 7 to 10, and 1 year extension, making the maximum validity to 11 years. So there were certain other amendments as well in the said notification. So like transfer of clearance, coastal zone clearance, then splitting of coastal zone clearance, and the validity basically was validity of coastal zone clearance basically was merged with the validity of EC. Now, in case of application, when any project proponent is making an application for EC, he can simultaneously make application for coastal zone clearance as well. So the validity of the EC and the coastal zone, depending on which type it is, it will concur. It would be it will have the same validity. Now, wildlife clearance. So wildlife clearance, if it is separately applied, wildlife and forest clearance, if it is separately applied, uh, other than along with the EC, so the validity would be specified in the clearance certificate itself. But if it is if the validity is made along with the AC, so it will coincides with the validity of the prior clearance. Now, in case of extension, now only one or two, maximum one or two extension may be granted subject to the type of project. So as I said, in case of area development project, in case of industrial and other project, so there's only one extension for 1 year that can be granted. However, in case of nuclear valley and river valley project and nuclear power project, so maximum one or two extension can be availed by the project proponent. Now, one important thing to note over here is, if any project or activity, let's say if the validity of EC is 10 years for any project or activity, and uh, project did not commence within the validity of EC, so in that case the EC will lapse, and for starting the project, now then the project proponent again has to make a fresh application to the concerned authority for fresh clearance. So now the next slide talks about the like whether EC can be obtained retrospectively. So EC, the basically EC has to be obtained. It should be a prior EC before the start of any project or activity. It cannot be obtained retrospectively. That is after initiating any project or activity. Now there's a latest. So I have quoted few Supreme Court judgments. Now, in case of a recent judgment, a Supreme Court judgment in the case Vanashakti versus Union of India. So, the judgment which came out on August 5, 2025. So, in that case, if we see certain project or activities falling under category under item 8A of EIA notification 2006, that is with respect to industrial shade schools or colleges. So basically, this was exempted. So the exemption from exempted from obtaining prior EC. So this exemption was struck down by Supreme Court in its judgment dated August 5, 2025, in the case of Vanashakti versus Union of India. Now here, so a very crucial thing to note over here is the term industrial shed. So if we see the definition of industrial shed provided by the Ministry of Environment, Forest and Climate Change, it says that any shed, whether it is of RCC structure or otherwise, which is used for accommodating plant and machinery in for any project activity or any manufacturing activity, including go downs. So including go downs. So if we see, then under this term, basically they have covered the go down as well as the any shed which is created for installing any plant or machinery or any which will be termed as a go down, which will be used for manufacturing or production activity. So those, the exemption has been struck down, and now prior clearance has to be obtained in case of go downs as well. Now the another thing to note over here is the projects like schools, colleges and hostels are now treated in par with other industrial projects, which where the other projects need to obtain prior EC. So now from post this judgment, even the educational institution, any project related to an educational institution, even they have to obtain prior environment clearance. Now other case, again the same case matter, Vanashakti versus Union of India. Now in that case, the judgment of Supreme Court dated May 16, 2025. In that case, Supreme Court has categorically barred post facto environment clearance. So what Supreme Court uh, has basically stringently it has notified that any project where the prior EC has to be obtained under EIA notification 2006, then it has to be obtained as a prior EC and not post EC, and not after start of the project or activity. Now this is a quite old judgment, which is like Alembic Pharmaceutical Limited versus Rohit Prajapati and others, wherein again it's a Supreme Court judgment dated 1st April 2020, 2020, wherein the Supreme Court had even earlier notified that the clearance, environment clearance, should be prior clearance and not ex post facto. And so if any clearance has been obtained after start of the project, it is against the fundamental principle of environment jurisdiction. So basically the judgment was already in place, but still some sort of leniency, the project proponent used to take the liberty and make an application for the EC post start of the project. But now has imposed stringency on, Supreme Court has imposed a certain very strict norm that no project should be entertained, project or activity applying post for post clearance should be entertained. The next slide basically talks about the major compliances post obtaining AC. So once the application is made, entire recommendations or the comments has been addressed, everything is the entire document has been appraised by the expert appraisal committee or the state or the UT appraisal committee, and finally once everything is in order, then the state impact assessment authority or the central impact assessment of environment impact assessment authority may proceed with issuing the environment clearance to the concerned proposed project proponent for the project or activity for which it is applied. Now once the EC is been obtained, so what are the major compliances the entity has to undertake for the relevant project or activity? The first one is publication of EC in newspaper. So soon the EC is obtained, so publication has to be, publication of the EC obtained by the project proponent for particular project has to be published in at least two newspapers circulated in and around the project location where the project or activity is located. The second one is submission of environment clearance to local authority. So soon the EC is obtained, so a copy of the same has to be submitted to all the local authorities where the other clearances or other approvals has to be obtained, or which is where the project or activity is located within the jurisdiction of that particular local authority. The third one is implementation of environment management plan. So as I said earlier in the earlier slides, so environment management plan is nothing but environment mitigation plan. So once the environment mitigation plan is finalized and approved by the appraisal committee, in that case, once the EC is obtained, so the unit or the project or activity, the project proponent has to keep in mind that the mitigation, any environment impact has to be mitigated immediately as per the plan specified in the environment management plan, or any change in the EMP later has to be notified to the concerned authority. Now, installation of online continuous monitoring system. So, environment impact post obtaining EC has to be regularly monitored by the project proponent for the project or activity for which the prior EC has been granted. So online continuous monitoring has to be done, and the report has to be submitted to the authority at regular interval. Now, maintaining the green belt and plantation. So in this case, uh, uh, for the project or activity where the EC has been granted, so for that project, at least 1/3 or 33 or more, at least 33% of the open area of that project, a green belt or plantation should be maintained throughout the term of the project or activity. Now, submission of half-yearly compliance report. So as a part of compliance, every half-yearly a compliance report has to be submitted. So basically, the compliance report um, the compliance of the terms and conditions specified in the environment clearance certificate. So whatever terms and conditions been complied, so a half yearly report, compliance report has to be submitted to the relevant authority, specifying the compliances of terms and conditions of the EC. Now, this half-yearly compliance report basically is a public document. So, is a public document, and this half-yearly report, once as soon it is received by the concerned authority, it will be uploaded on the website of the authority, and anybody can access the half-yearly compliance report of any project or activity being filed with the authority. Now, if let's say if I, not being the concerned stakeholder and need a copy of it, I may make an application to the authority for a copy of half-yearly compliance report of any project or activity, though I may or may not be a stakeholder for that project or activity. Now, next is no pollution load certificate. So no pollution load certificate, this is applicable in case of modernization, expansion, or change in product mix. So if any change in product mix or any modernization or expansion happening to the existing project for which the EC has already been granted, and in the EC, the threshold for environment impact has already been specified, if due to that expansion, modification, or product mix in the existing activity, the total capacity, if it is going to change or exceed the limit which is specified in EC, so in that case, uh, again, the project proponent has to make an application for prior environment clearance. On the other hand, if such expansion or such product mix or such change in a project or activity, if it's not going to trigger the pollution load that has been specified in the existing EC, so in that case, no load pollution certificate has to be submitted to the authority in Form 10. Again, this has to be submitted online through Parivesh portal. Now, the next one is obtaining CT and CTO. Generally, in case of CTO, it is simultaneously either at the time of making the application, project proponent generally has the CTE in place, or probably in certain cases the application is made simultaneously for application for EC, and CTE is made simultaneously. Simultaneously. In certain cases where the EC is made prior, so and the EC has been granted, and it will have some sort of uh, like air emission or trade or water affluence. Basically, the project or activity will emit any air emission or any effluence. So in that case, CTE and CTO has to be obtained under Air and Water Act, respectively. So the conditions with respect to obtaining the CTE and CTO will be specified in the EC itself. Public grievance redressal mechanism. So here, every project and or activity should have a well defined public grievance redressal mechanism, so that any at any point of time, if any grievance is received from any local any person, any individual or affected party or affected stakeholder, so in that case the timeline should be should have a policy in place or mechanism in place to redress the grievance of that particular stakeholder or the affected party. Now, maintaining the records and documentation. So whatever compliances that we discussed in this, that I have discussed in this slide, for every documentation, every record has to be maintained with respect to that project or activity for future investigation or site inspection by the relevant authority. The next slides, basically, this slide talks about the penalties under Environment Protection Act. So if we see, or if we go through the EIA notification 2006, per se, it doesn't provide for any penalty or any penal provision in it. Now, since the EIA notification 2006 is notified under the EP Act 1986, the penalties has been derived from this act and rules. So let's see what are the penalties provided under the EP Act 1986. Now, Section 15. So Section 15 basically talks about any contravention of provision of Act rules, orders, and direction. Now, if any provision of the Act rules, that is the EP Act, EP rules, or any orders, guidelines, or any directions which is issued under the said act and rules, if it is contravened, then in that case the fine would be minimum of INR 10,000, which may exceed up to rupees 15 lakh. And if the contravention is a continuous contravention, in that case the penalty would be INR 10,000 every day till the contravention continues. It will get accumulated. So basically, the penalty will get accumulated. Now, under Section 15A of the said Act, contravention by company. So any contravention is done by the company. So in that case, it's an escalated fine. Now, in case of company, so instead of 10,000, it would be 1 lakh. The minimum penalty would be INR 1 lakh, which may exceed up to rupees 15 lakh for one time contravention. But if the contravention is a continuous contravention, so in that case the penalty in unlike in the earlier case where it was 10,000, but in case of company it would be INR 1 lakh every day till the contravention continues. So basically the conclusion, basically the gist of this section is, if any contravention is being done by the company, then the penalty, there's a huge penalty for such contravention. Now, Section 15C. Section 15C basically talks about environment compensation. Now, environment compensation either in the form of polluters pay principle, may be imposed by either the relevant authority or by entity on the project or activity for which any environment impact, a major environment impact has uh, taken place. Now, if we see the latest judgment of Supreme Court, which was dated 4th August 2025 in the case matter Delhi Pollution Control Committee versus Lodi Property Company Limited. So under this judgment, Supreme Court has Supreme Court has ordered that Pollution Control Committee or Pollution Control Board has the authority to impose environment compensation on any project or any activity where they are where they find out find out that the due to such such project or activity a uh, major environment uh, impact has taken place. Now, under section 16, so basically section 16 talks about offense by company. So under offense, in case of this offenses by company, so in this case, where the offenses has been committed by company, so every person who was responsible for the project or activity, or who was having the control of the project or activity during that time which the offense was committed, will be proceeded against and punished accordingly, unless and until he is unless and until he can prove that these was done with the non-compliances or uh, offense was done in his absence, or he had taken due steps to prevent the offense. Now, another scenario is in case if the offense has been done by the company and there was the involvement of or the negligence of the directors, officers, or uh, directors or other officers of the company, and it is proved. So, in that case, such persons, such individuals, that is the directors or other officers, would also be proceeded against and punished accordingly. Now, in case of section 15, failure to pay penalty. So basically, this is a additional fine being imposed on the unit or project or activity. So in case if in any unit or any activity fails to pay the penalty or additional penalty as defined under section under the Environment Protection Act. So in that case, the failure may result in imprisonment which may exceed up to 3 years, or twice the fine, or both, as the relevant authority may deem fit. Please excuse me. Okay. So what are the other consequences of non-compliance? So other consequences of non-compliance may be a stall of project or activity, or closure of project or activity. So if we see the judgment of uh, Supreme Court judgment in the matter of Vedanta Limited versus the state of Tamil Nadu and others. So in that case, basically the permanent closure of copper factory, so erstwhile Sterlite Copper Industries, and now which is formerly it was known as Sterlite Industries, and now it is Vedanta. So basically permanent closure has been of copper factory has been ordered due to non-compliance of EC condition. So basically Vedanta had procured EC well in time, everything was well in place. The only thing where it went wrong was the compliance of terms and conditions of EC. It neglected the environment and the health of people staying around the location where the copper factory is located. So in Vedanta Limited basically had filed a plea as well with the Supreme Court to reopen the copper factory, but Supreme Court, by its order dated Feb 29, 2024, so basically dismissed the plea for reopening of the plant. Reopening of the plant. So as of now, there is no authority or any approval or any authority or judgment where the reopening can happen. So basically, this is a very classic case where we can quote what the consequences can be in case of non-compliances of the terms of EC. EC. So yeah, so the next slide here, basically I'll be explaining the services provided by Aparajitha Corporate Services Private Limited vis-a-vis environment clearance. So now so there are four. It's a very broadly I have classified four types of services. One is product. So we have a software as a service wherein any entity. For our client, basically, the compliances applicable to the client is being triggered, is being configured in the software tool, and then the compliances is triggered as per the statutory norms, then the second one, and also any notifications or any updates been happening on regular basis is informed or it's sent across the client via the said software. Now the next one is licensing. So licensing here in case of EC, with respect to EC, everything with respect start from procurement of the environment clearance, again the extension with respect to split of EC, surrender of EC, then transfer of EC, everything with all the services with respect to licensing is being carried out by Aparajitha. Now services, other services, in other services, it's like the end-to-end EC compliances with assurance. So everything that comes under the EC compliances, everything is undertaken by Aparajitha with assurance. Now advisory. So in case of any advisory or opinion is required on any provision or any case, so yeah, any provision or statutory provision of the regulation with respect to EC. So basically we provide advisory as well. Now since this session was particularly on environment clearance, the services that I discussed is very particular with respect to EC. However, so we at Aparajitha, basically we provide all the four services for all the legislations, for all the legislations falling under under the domain of environment, health and safety. So that's it. So it's a Q&A session.
Thank you for your session, ma'am. In case anyone has any question, you can start with your questions now. Ma'am, there is one question in the chat. You can go through it.
So, okay, what is the
So,
typical time required to get EC? So basically, if we see the typical time required to get the EC may vary uh, the expert appraisal committee may come out with at the time of appraisal they come out with the comments and then recommendations, and then again the comments has to be the EMP, that's a EIA and EMP may have to be modified and submitted again. So, but the tentative timeline, if we see for getting the EC, is around 2 months. Any other questions? Is public hearing consultation mandatory for construction project below 1,50,000 square feet? So any project falling under the construction project, any construction project which is below 1,50,000 square feet, uh, below 1,50,000, it comes under the category B2. So for B2 category project, public consultation is not mandatory. Can you explain the process of annual half-yearly return report and what happens? For this question, I mean, we can note down this question and we can revert you back via email. So any specific timeline defined for public hearing? Yes. So basically for public hearing, it is 45 days. It should conclude within 45 days.
ma'am, there is one more question above, which is why 33% of greenery is required. We do not have the land. What is provision?
So basically, see, I mean, in the term, if you go through the environment clearance certificate, in that it will be specified. This is a general percentage we see in maximum environment clearance, which is granted for project or activity. So whatever like the greenery has to be required, whatever percentage of greenery has to be required to be maintained for that particular project or activity, it will be specified, clearly specified in the EC itself. Open area as well, or only green belt? So basically the entire 33% includes the entire open area, which may include the green belt.
There
Any
is
other
one more question
questions?
above. Yeah.
Yeah.
It was told that during June to October, we cannot perform testing required rainy season.
Where is this question? I'm not able to get this.
It's about by Mr. Yogesh. Just come below.
Uh, um, not able to see this query. So Shreya, if you could read it for me.
Kindly scroll down now. It's after MOEF. Yeah.
Okay. So it was told that during June to October, we cannot perform testing required rainy season. Okay. So see, this is on case to case basis. The authority may recommend any conditions. This is not something very stringent or prevailing for all the project or activity. It is very specific. So it is up to the authority. So open area, green belt, but space is not available. So see this EC terms and conditions. So every project or activity is thoroughly reviewed and evaluated by the appraisal expert appraisal committee, and on the basis of the evaluation, basically they come out to a conclusion as to what space has to be allotted for green zone or the green belt area for the particular project. This, yeah, so for the question with respect to can we take the land on rent and develop the same, we will get back to you on this over email. Shreya, please note down this query.
Sure,
Does
ma'am.
EC amendment required if there is no change in Thus, EC amendment required if there is no change in build-up area, but change to be made in water discharge or DG addition. So, in case of water discharge and DG addition, so in this case, basically the project activity need to obtain a consent to establish and consent to operate. So EC is required in case of any project which is falling under the schedule of EIA notification 2006 or the other categories as I discussed, which is falling within the either the forest zone or eco-sensitive zone. So only in that case. Any other questions?
I think those are the only questions which I have.
Okay. So any further questions? Okay. So going forward, EC audit will be mandated by MOEF or SPCB. So AEC basically environment clearance comes within the purview of Ministry of Environment, Forest and Climate Change. It doesn't come under SPCB. So basically the consent to establish and consent to operate comes under the purview of Pollution Control Board.
I think there are no further questions, right?
Okay, so any further questions can be in case if it's later you come up with any further questions, you can write to our at the email ID provided by us, and we will
Yeah.
address the concern ASAP.
We are putting the email address in the chat box also. Meanwhile, we'll be sending a mail across for the same.
Okay.
So thank you, ma'am. Thank you, everyone.
Uh, Thank you for making the session more live and interactive. Thank you.
Thank you.